everybody, it's Valerie Zammitti of Zammitti Law, where we provide peace of mind to families through estate planning, elder law, and probate matters. Today, in the next few minutes, we're going to try to answer the question of what healthcare directives do I need? Before we get there, however, if you have any further questions about this topic or anything else estate planning and probate related, please feel free to reach out to us for a free conversation at yourplanningattorney.com. That's yourplanningattorney.com. Now, this question is fairly straightforward, basic. We're trying to give some overview educational discussions so that general knowledge of the types of documents you need or may want are understood by everyone who's seeking to start their estate planning. So to answer the question of what healthcare directives you need, in our mind, there are three distinct areas that need to be covered. The first is a healthcare proxy. In some states, it's called a healthcare power of attorney. And this, again, similar to a financial power of attorney, is where you designate your trusted agents, trusted typically family members, to make health decisions on your behalf if you were incapacitated. These individuals would make general medical decisions on your behalf and help you through that sort of period. A tip again, just like the financial power of attorney, is to make sure you designate multiple successor agents. If the first person isn't available, you want to make sure you have 1 to 2 backups. We typically like to have 2. A living will is the second healthcare document that I would suggest that you have. A living will essentially covers the particular and specific circumstance if you're in an incurable, irreversible state with no chance of recovery, and there was some sort of extra resource being used to sustain you in that state, such as a ventilator or a artificial feeding tube, or even an IV sustaining you in that state. It's important that you discuss these wishes, general wishes, with your family members before you implement this document so that those specific items are very well known by everyone. Thirdly, you do need to make sure you have what's called a HIPAA authorization. Back in the mid-90s, I believe, there was the privacy laws that came about, and it restricted the information flow even further, even for family members trying to help make medical decisions. And so the HIPAA is a very important document so that everyone can receive your medical information to make the right decision on your behalf. You should know that various states, various attorneys have a preference sometimes as to whether these 3 particular pieces should be together or separate. It's my particular preference for my clients and my firm to separate them out, especially with a living will where the end of life decisions are fairly specific, and I wish for my clients to designate the statements with which they agree specifically. Well, that's it for today. And as a reminder, if you have any questions, you can feel free to reach out to us for a free conversation at yourplanningattorney.com. That's yourplanningattorney.com. Thank you so much for listening. And if you found this helpful or think someone else may, please like, share, and subscribe where appropriate so nobody misses out. Again, I'm Valerie Zammitti from Zammitti Law, where we provide peace of mind to families through estate planning, elder law, and probate matters. Thanks. Be well.